Senator Van Hollen.
Thank you, Mr. Chairman. Mr. Attorney General, this is an outrageous, unprecedented slush fund that you set up. Simple question, will individuals who assaulted Capitol Hill police officers be eligible for this fund?
Well, as it makes plain, anybody is
just let me know if they're eligible for the fund.
As was made plain yesterday, anybody in this country is eligible to apply if they believe they were victim of weaponization.
Mr. Attorney General, let me ask you this. Are there going to be rules that say that if you've assaulted a Capitol Hill police officer or committed a violent crime, you will not be eligible? Why not make that a rule?
I expect that, because I'm not one of the commissioners setting up the rules, I expect that there will be rules.
You're appointing 4 of the 5 members, aren't you, Mr. Attorney General?
Pardon me?
You're appointing 4 of the 5 members.
I am appointing all 5 members. You can certainly
set up the rules. I would hope you would make a rule that anyone convicted of assaulting a police officer or a violent crime is simply not eligible. They should not apply.
Well,
let me ask you this, because you compared it to the Keepsiegel case. But I think you know full well that in that case, the settlement agreement was approved by a federal judge, including the payments to people who were not originally parties to the lawsuit. No federal judge has approved this fund, have they, Mr. Attorney General?
No federal judge did approve this.
So that's a big difference between this case and the case that you compared it to.
No, it's not.
Well, did a judge sign off on this case?
No.
A judge did sign off on the other one.
Yes, but your question was whether it's a big difference. It's not.
Of course it is, because that allows for an independent person to look at it rather than the
There was no independence. There was no independence. There was a single commissioner. A judge signed off on it. A judge had nothing to do with deciding the money.
There was a judge who looked at it and signed off on it. So to compare that case to this one is incredibly deceptive. Let me ask you this about the Epstein case, because as we speak, many Epstein survivors are in New York. They're reading portions of the Epstein files about the abuse that they suffered. Otherwise, they might have been here with us today. At a House hearing, your predecessor refused to acknowledge the pain experienced by some of those victims when the administration improperly released their names in identifying information. So I want to know where you stand. I spoke to the representatives of some of the Epstein survivors yesterday. They are extremely frustrated that you keep calling for people to come forward with more evidence, but you have not met with them to hear their stories. So simple question. If I connect you with these survivors, will you meet with them?
Absolutely. And what you just said is false. I have met with them. I've met with many of the lawyers for the survivors of victims, as did Attorney General Bondi. So whoever told you that, unfortunately, gave you bad information.
Okay.
And I would encourage them to reach out to the Department of Justice, because like we do every single day, we absolutely care for victims, and we absolutely want to hear from them and their lawyers.
Well, I've been told directly from the representatives they've not had a chance, at least this group, to meet with you. So
did they represent that they asked?
So I'm glad to hear that.
Did they represent they asked for a meeting?
Can I ask you to commit that the Justice Department will not recommend a pardon for anyone named in the Epstein files?
Can you repeat that question? I'm sorry. I didn't hear what you said.
Can you commit that the Justice Department, you, the acting Attorney General, will not recommend a pardon for people named in the Epstein files?
When you say people named, there's tens of thousands, hundreds of thousands of, quote, people named.
How about Ghislaine Maxwell? Can you commit that you will?
Yes, I can commit to that, of course.
Okay. Let me go back to this slush fund, because there's also an individual who, after being pardoned by the president, went on to molest 2 children. And that person actually tried to buy the silence of these children by saying that he would pay them some of the funds that he was hoping to get from your slush fund. Can you commit to making the rules so that that person is not eligible for a payout under this fund?
Well, you're obviously lying in your question, because there's no way that this person committed to that. But the slush fund, as you call it, which is not, didn't exist.
I'm sure,
but I can commit.
Mr. Attorney General, don't ever do that again. I am reporting
what again?
What he said. He said on the expectation that he hoped to get some of the funds from a payout. He's been
you said from the slush fund, Senator, and that didn't exist when he said that.
This is the fund that the president and all of you have been telegraphing all along that you're going to use to help the president's friends.
Can you point to a
Mr.
single
Attorney General, I
telegraph
have a
I
last
made?
question.
What telegraph did
I have a last question for
Okay.
you. Do you know that it is a criminal offense to lie to Congress?
I am very well aware of that.
I'm glad to hear that. Thank you.
There is a sentence in this exchange that the acting Attorney General of the United States said to a sitting senator in a sworn congressional hearing, "You are obviously lying in your question. Not, I believe that characterization is inaccurate. Not, the record does not support that claim. Not, I would push back on that framing. You are obviously lying in your question," directed at a United States senator, on the record, under oath. The senator's response was immediate. "Do not ever do that again." He said he was reporting what a specific individual had said, that the accusation of lying was directed at the senator's account of someone else's words. And then the senator closed the exchange with a question that is now the last thing in the transcript before he yielded. "Do you know that it is a criminal offense to lie to Congress?" Blanche said he was very well aware of that. To understand the full weight of what happened in that room, the exchange has to be followed from its opening. Because the closing question was not a separate thought, it was the destination of everything that came before it. Senator Chris Van Hollen of Maryland opened with a direct characterization and a direct question. He called the fund an outrageous, unprecedented slush fund. He asked whether individuals who assaulted Capitol Hill police officers would be eligible to receive money from it. Blanche said anybody in the country is eligible to apply if they believe they were a victim. Van Hollen stopped him. "Are there going to be rules, specific rules that say if you assaulted a Capitol police officer or committed a violent crime, you are not eligible?" Blanche said he was not one of the commissioners setting up the rules. Van Hollen's response was the first significant exchange of the hearing. "You are appointing 4 of the 5 members, are you not?" Blanche corrected him, "All 5. I am appointing all 5 of them." Van Hollen's point was unchanged. If you are appointing all 5 commissioners, you can set the rules, you can make that exclusion happen. Blanche said he expected the commissioners would address that. He did not commit to directing them to do so. Those 2 facts now sit in the record simultaneously. Blanche controls every appointment to the commission. He has not directed the commission to exclude individuals convicted of violent crimes against police officers. Van Hollen then moved to the legal comparison Blanche had drawn, the Keepsiegel case. In Keepsiegel, a federal judge approved the settlement agreement, including payments to individuals who were not originally parties to the lawsuit. Van Hollen asked directly, "No federal judge approved this fund, correct?" Blanche confirmed, "No federal judge approved it." Van Hollen said that was a significant difference between the 2 cases. Blanche said it was not. Van Hollen pressed, "A judge signed off on one case and not the other. That is a significant difference because it allows an independent person to review the process rather than relying entirely on hand-picked commissioners." Blanche said there was no independence in the Keepsiegel case either, that a judge signed off on it but had nothing to do with deciding the money. Van Hollen's characterization of that argument is now in the official record. He called the comparison incredibly deceptive. That phrase, directed at the acting Attorney General's legal analogy in a sworn congressional proceeding, is in the transcript. It will be there when the confirmation hearing begins. Van Hollen then raised the Epstein survivors. He noted that as the hearing was taking place, survivors were in New York, reading portions of the Epstein files about their own abuse. He said he had spoken to representatives of those survivors the day before. Their message: they are frustrated that the department keeps asking people to come forward with evidence while refusing to meet with them directly. Van Hollen asked, "If I connect you with these survivors, will you meet with them?" Blanche said, "Absolutely." And then he said what the senator had just stated was false. He said he had met with survivors. He had met with many of the lawyers representing victims. Whoever told Van Hollen otherwise gave him bad information. He said he would encourage survivors and their lawyers to reach out to the department. Van Hollen said he had been told directly by representatives that this specific group had not had a chance to meet with Blanche. He said he was glad to hear Blanche's commitment. That exchange, 2 conflicting accounts of what has and has not happened, neither of which can be resolved within the hearing, is in the record. Blanche's account and Van Hollen's account sit next to each other without resolution. Van Hollen then asked Blanche to commit that the Justice Department would not recommend a pardon for anyone named in the Epstein files. Blanche noted that hundreds of thousands of people are named in those files. Van Hollen narrowed it. What about Ghislaine Maxwell? Blanche said yes, he could commit to that. That commitment is now sworn into the official record of a congressional hearing. The acting Attorney General of the United States stated under oath that the Justice Department will not recommend a pardon for Ghislaine Maxwell. That statement travels forward into every future discussion of Maxwell's status, her cooperation, and any administration decision about her case. Then the exchange reached its most direct and most contested moment. Van Hollen described a specific individual, a person pardoned by the president who subsequently molested 2 children. He said that person tried to buy the silence of those children by referencing money he hoped to receive from the January 6th fund. He asked whether Blanche would commit to making rules that would exclude that person from receiving a payout. Blanche's response was immediate and categorical. "You are obviously lying in your question." He then added that there was no way this person made such a commitment and that the fund did not exist at the time the alleged statement was made. Van Hollen's counter came in 2 parts. First, do not ever do that again. Second, he said he was reporting what the individual said, that on the expectation of a future payout, this person made statements to children. Blanche interrupted to say the fund didn't exist when the statement was made. Van Hollen's response was the line that captured the entire exchange. "This is the fund that the president and all of you have been telegraphing all along that you were going to use to help the president's friends." Blanche asked Van Hollen to point to a single telegraph, making that case. Van Hollen said he had a last question. "Do you know that it is a criminal offense to lie to Congress?" Blanche said he was very well aware of that. Van Hollen said he was glad to hear it and yielded. 2 things can be true at the same time. The legal distinction Blanche drew on the keep-sequel comparison is a real one. Judicial oversight of a settlement's existence is different from judicial oversight of how funds within that settlement are distributed. His correction that he did not say Van Hollen was lying, but rather that the characterization of what the pardoned individual said was wrong, is a distinction worth acknowledging. And his categorical commitment on Maxwell, placed under oath in a congressional hearing, is a real and consequential statement that either holds or becomes evidence of something more serious. Both of those are reasonable positions. So here is where this exchange leaves us, and it is genuinely 2-sided. Was Van Hollen conducting rigorous oversight, pressing the acting Attorney General on judicial accountability, survivor access, and the legal exposure of an official who called a senator's account an obvious lie? Or was he running a political prosecution using loaded language to build a record around a nominee his party intends to oppose? Was Blanche defending legitimate decisions and correcting mischaracterizations in real time? Or was he calling a senator a liar in a sworn proceeding to deflect a question about a fund he controls entirely? 2 different stories, same hearing, same official record. Tell me in the comments which version you walked away believing. If you stayed this long, subscribe. The commissioners have not been named. The rules have not been set. The record is watching both.